try and squeeze in a couple of questions here. Michael, this one did drop in during your segment. It is open to everybody, but it's just asking, perhaps you want to lead us off, and the question's just asking, do you recommend using non-compete provisions, or would you rather scale back and maybe revert to non-solicitation covenants? So we'll start with you, Michael, and if any of our other speakers have anything to add, we'd love to hear it.
That's a good question. My notion is, and I'm trying to dissuade employers from utilizing them for all the reasons that we heard in the last 2 hours. A lot of courts dislike them. It's hard to enforce, just like our last speaker, Ibrahim, outlined. It's hard to apply the scope to determine the legitimate business interest. If you're too narrow, it may not help the employer. If you're overly broad, it will be considered unreasonable just because of all the risk. Plus, the law is constantly in flow. In a sense, the evolution is ongoing. With one exception, Georgia, as we learned today, going the other direction. So the risk is fairly high that something that you draft today may still be enforceable as of February 17, 2021. But in a year, 2 or 3, the evolution of new state law and maybe possible federal law coming into effect could then render it obsolete and unenforceable. So that was my recommendation earlier in the presentation, and that's my opinion. But we have 4 speakers, so there might be other opinions on the subject.
Thank you so much, Michael. Any other opinions before we move on?
This is Jim Gale. I'll tell you the way in which I like to do things, depending upon the state. Where blue penciling is permitted, I see no reason not to go forward with a geographic covenant first, then to have a decreasing restriction that applies to solicitation of customers only, and then go even more narrow to just a non-disclosure, etc. By doing so, if your geographic non-compete is too broad, and even if it gets knocked out and is not enforceable, you still can rely upon the non-solicitation of customers. So I see no reason not to put in a broader covenant not to compete, and it sometimes gives the judge the opportunity to throw that out and yet enforce the more narrow non-solicitation of customers. So I'm a big fan of going broad.
Thank you so much for that, James. And Chip, a quick question that dropped in during your segment here. Just asking, in what circumstances would a plaintiff rely on a damages claim only, as opposed to perhaps seeking a preliminary injunction?
Yeah, as far as some of the circumstances why a plaintiff might skip the preliminary injunction stage, I think Abby hit on a key one, and that is sometimes the damage has already been done. For instance, if you have a salesperson who went to a competitor and immediately has already landed or switched over his or her top customers, they're already gone, then yeah, a preliminary injunction's not going to do you any good to stop any further solicitation. The second would be sometimes your covenant has expired by the time you either find out about it or file your lawsuit, and there's no tolling claim, no equitable tolling. So again, you're not going to be able to get an injunction, so you're stuck with damages. And third would be, this is a real practical one, but it's one I've had to consider before. If you have real concerns about the enforceability of your covenant, you've got to think about how quickly you want to bring that covenant and get a ruling from the judge, and your case may be over real quick if you file a TRO and you get an adverse ruling on enforceability. And then finally, there's some instances where you know there's some smoke there, but you just don't have enough evidence to prove the fire, and so you don't want to start the case off with a loss at the TRO stage, and again, going to it's your chance to make a first impression. So you may want to go through discovery and then just have a jury trial on damages and possibly a permanent injunction.